All right.
Good morning.
Next case is Alquawasme versus State.
Yeah, please, the court. My name is Chris Altenburn, and I'm member Banker Lopez Gassler, and I'm here today representing Amjad Al-Khawazmi. And I'd like to save 5 minutes for my rebuttal in this
Sure.
proceeding. It is Mr. Al-Khawazmi's position that the circuit court departed from the essential requirements of the law because that court had no authority to regulate the sheriff's conditions of confinement of an individual prisoner that had been transferred to that portion of the executive branch.
Is that a jurisdictional issue, Mr. Altenburn?
No, I think it's probably a departure from the essential requirements of the law. I think that.
Well, I mean, a jurisdictional issue may well be a departure. I think.
Is it a jurisdictional issue in the circuit court? Is that your? Is that
correct. And yes. I have it. Yeah. Yes. And I have it. Yes. You're right. Right. Of the circuit court. Yeah. I especially have a concern here. This was well after, I think, I did the math correctly. You know, the motion for reconsideration time well after the state's appeal time. And I just don't know what the trial court's jurisdiction was at that point.
And let me explain, I doubt that the court had jurisdiction over the subject matter of this.
Right.
The appeal time had not run when.
The appeal time for the state, if the state had an appeal, that had run.
That had run, you're right, that's 15
And then the
days
state's cross appeal time was renewed when the, correct.
And the motion they filed is this motion to clarify a sentence, which is
right.
a motion unauthorized by any known rule of criminal procedure.
And they couldn't file 3800B because it wouldn't benefit the defendant.
Yeah, it has to benefit the defendant, and they could not do that. By the way, during the pendency of this in the appeal, I have filed a 3800B2 to correct a jail credit issue, but that's a separate issue.
And that was on the jail credit issue on the second count.
Yeah, they gave 395 days on a 365-day sentence. So
right, right.
So now his release date is sometime probably in January rather than.
But that 3800, your B2 motion is filed in the context of the other appeal that has come up. Okay.
That's correct. It doesn't have anything to do with the certiorari proceeding.
Right.
But what happened here was when they filed their motion, I appeared on a Friday and filed a motion to strike. It was set immediately for Monday. I wasn't prepared, so I filed my notice of appeal a few days early. So I would have the position that not only was this going to violate double jeopardy, but
whatever jurisdiction there was had been divested.
Yes. And at that hearing, by the way, when we got through that portion of the case, the judge said, it appears to me I have no jurisdiction. And so the state then, that's transitions, it's page of the appendix 123, transitions to, but wait, I have this other argument, which is you don't need to modify the sentence by adding things to it because the sheriff's electronic monitoring program is illegal because he just can't do this. And their basis was that it was in violation of Administrative Order 2018-20. Now at that time, by the way, that administrative order was not on the 6th Judicial Circuit's website. They found it by quote unquote crowdsourcing to find it. I noticed yesterday it's back on the website. But one way or the other, we're in a hybrid hearing. I'm on Zoom, my co-defendant counsel is on Zoom, but the ASAs are in the courtroom. And so they simply hand the judge a copy of this administrative order. I don't have anything. And they proceed to have this discussion about whether or not the sheriff can do this under the administrative order.
Mr. Altenburn, good to see you, sir. Even if that administrative order were something that wanted to be attacked, was there proper notice given to any of the parties?
There was no pleading. There was no notice. I mean, there's a, if nothing else, it's a clear procedural due process violation. Yes, I'm sorry.
And did the state, though, did the state explain why the alleged illegality of what the sheriff did granted Judge Hellinger jurisdiction in your client's case?
No, they did not. And frankly, when a couple days later, when I finally got a copy of this administrative order, I realized that it was the uniform bond schedule. And at the
Right.
end of it, it has 3 sections about how to release prisoners to prevent prison overcrowding. when
It's a
the
strange
prison gets-
combination in that order.
Yeah, and,
So you don't
But-
have, yeah,
right, but the
which
sheriff's
is why the
program,
state, probably why the state had to crowdsource to find it, because it wasn't reflected in the
right,
title or anything up top.
So in effect, when they transitioned that argument, the sheriff and the sheriff's program became kind of the central target, but they weren't there to defend their program or anything that was happening. It's no different than the weekend work release program or other programs. Sure, they may or may not ultimately stand up, but if somebody were going to attack those programs, the sheriff should have been noticed, and it shouldn't have been in your client's case. Is that your
But
argument?
that's exactly right. Under Bell versus Wolfish, the courts have limited jurisdiction here. The sheriff, like the Department of Correction, is the executive branch person that is in custody, has charge of the custody of this person. They have control over where to do this. If you want to put a prisoner in a hotel room with a guard, you can do that. You want to, if they need to go to hospital, as happened in this case, you take them to prison with a guard. When I was a sheriff's attorney, a couple times I put him on the couch of the sheriff while I tried to figure things out. There are, as an independent constitutional officer, unless there is a statute that retains jurisdiction or gives jurisdiction to the court to micromanage the sheriff or the Department of Correction, they can't do that. You know, we had many cases in the 70s about you can't put them on hard labor because there was no statute. We had one judge in Hillsborough County that would order people to be shackled at all times when they were in prison, and those were unauthorized. And this isn't as extreme as that, but this sheriff, in conjunction, I think, with the county commission, if they want to participate, can make decisions about cost-effective handling of prisoners that's safe for the prisoner and provides an adequate form of confinement for that prisoner.
Obviously, that at some point, someone has made a determination that 3,300 is the number for that jail facility.
Yeah, if I had to bet,
We don't know where that came from.
no, if I had to bet, it's a federal lawsuit or a federal regulation on.
Right, who knows? Who knows? It just could be good, you know, they're good management. Who knows what it is?
Keep in mind, the
Let me
sheriff,
ask you a procedural issue. If this was not a jail sentence, but a prison sentence, if this was, you know, and this order had been entered, you would have an appellate right? A right to an appeal. You have a right to an appeal. And I assume you would say that the appeal is not an adequate remedy because it would take too long and his sentence would be up in the meantime. But at this point, the judge has stayed her order, has she not? Is that still in effect?
I know that there's a hearing set to re-examine this as soon as this oral argument is over sometime in the next few weeks.
Okay. Well, because I was gonna if the order is stayed, he's still serving his sentence at, I think, his brother's house, and the only thing that is stayed is directing him back to the jail facility. In that case, would we, I guess, you know, it's just weird. If we were to say, okay, well, you know, now an appeal might be an adequate remedy because, you know, it wouldn't be an adequate remedy for the state, actually, because his sentence would expire while the case was on appeal.
Right. If
It's
she had
not
handled,
far, it's not terribly far from expiring at this point, is it? I mean, when was he sentenced?
the last information I had was the end of January, and I'm not sure whether that adjusts for the 30 days that I got him on the motion or not. But by the end of January, 75 days from now, it'll be over. And if the stay is in place through that time period, I would assume that this would become moot, capable of repetition. Frankly, it is
Well,
capable
yeah.
of repetition because
There's a
this is dispute-
suggestion that Judge Hellinger has an animosity to to this program altogether. Although that's not really fleshed out.
Yes, that's correct. It's not in the record. I will tell you that one of the reasons that I go to the proposition that the court has no authority to do this period without a statute is that there is a disagreement among judges in the Sixth Judicial Circuit about whether they even have authority to do this. I suspect that
Whether
if
the
sheriff-
judges have authority.
to tell the sheriff he can't do this process because there's no statute that gives them authority to tell the sheriff he can't do what he believes is the appropriate form of custody. You know, the sheriff, I can't depose the sheriff. I got no mechanism here, and he's not shown any interest in getting involved in this. But I suspect his position would be, I gave them the right to tell me that they didn't want to do it as a matter of political courtesy, not because there's any law that compelled me to do this.
Right.
I have the power to do that would be his position. And it is important to keep in mind that if this order isn't quashed, the judicial branch is telling my client to leave that room in his brother's house and go to cell block C. And the sheriff, who is the executive branch person in charge of his person, is telling him to stay exactly where he is. So he's got to pick whether he obeys the executive branch of government or the judicial branch of government as things stand right now. And I mean, to put this man in the middle of a fight that's between the courts and the sheriff just is inappropriate. So for many, many reasons, this departs from the essential requirements of the law on this. And obviously there'd be a procedural due process problem, even if there weren't one. So we're asking that the petition be granted, the order be quashed, and that he be allowed to serve out the remaining 75 days of his sentence under the conditions of confinement that were determined by the sheriff as a member of the executive branch that's in custody of his person. So unless the court
Let me
has
ask
more
you
questions.
one, for lack of a better, not a statutory construction, but an AO construction. There seem to be two numbered paragraphs in this administrative order that might or might not apply here. I think you're in your client situation, the sheriff's office was proceeding, I think it's paragraph 12 that has the, these are the stepped assessment criteria.
Mhm.
And then Judge Hellinger was looking at paragraph 13, which seems to say, and how do you reckon, and 13 requires the judge to permit the reassignment or order the I don't know what you call it, supervised, it's not release, it's supervised, whatever it is, GPS monitoring or whatever.
Right.
And paragraph 12, one of the criteria is that if he meets the other criteria, one of the criteria is that for not allowing it is if the judge says no. So it's two flip sides of the coin. How do you reconcile those?
Right. Yeah, the 13th provision says at the end of it, the sheriff has and continues to have the authority to place a misdemeanor or felony inmate on electronic monitoring or alternate sentencing if specifically authorized to do so in the judgment and the sentence or other specific order of the court. And I think the position I have to take beyond the due process that I didn't have a chance to read this before the hearing is that I don't know what loss gives the circuit court judge, the chief judge, the authority to say this. It's an executive officer who has his own authority under Florida statutes and under the common law actually before.
And probably under the Florida Constitution.
Right. The sheriff was actually a common law British style officer in Florida before there was a constitution. And
right.
The notion that this statute, that this administrative order is legal in that regard, I have great doubts about that. And certainly we never had an opportunity to brief that or argue that in front of the trial judge.
Okay. All right. Thank you.
And
you have 5 minutes.
Thank you very much.
Roscoe.
Good morning, Your Honors, and may it please the court. My name is Michael Roscoe, and I'm representing the state of Florida respondent. The state requests that this court dismiss the petition of Mr. Shari for two reasons, and that's that the petitioner has failed to establish irreparable harm, and second, because the trial court did have concurrent jurisdiction to enter the order that it did on the state's motion to clarify. I would like to begin with a very brief recitation of the facts beginning at the sentencing hearing in order to frame the state's arguments on the first issue for irreparable harm. The petitioner was convicted of 2 misdemeanors, and it went to the sentencing hearing on May 22nd. At the sentencing hearing, the only issue that was being argued about, because the petitioner's sentencing counsel was already on notice that the state was going to be seeking or requesting the maximum penalty, and that was consecutive sentencing for the 2 misdemeanors. By the time of sentencing on May 22nd, the petitioner had already been in jail for 13 months. So that would have made the difference about whether or not he would have been released at the time. But it was very clear based on the transcript of the hearing, and even the sentencing counsel, who was arguing that, whose primary argument was that the sentences should not be consecutive, but should run concurrent. And there was no issue or no argument about whether or not the petitioner should be spending his time in jail or alternative release or any other method, because he was already in jail. Like I said, he had been for 13 months at that point. And so it was essentially a foregone conclusion. And I think the counsel had mentioned that, multiple times in the hearing. So after the hearing, the judgment, sentence, and commitment forms were issued on that day, May 22nd, and it included the sentence. That's actually part of the record. That's the appendix attached to the response. And that was the commitment form that issued the day after the sentencing on May 22nd. On that day, the commitment form that issued that day included the information that said that the sheriff should not include this individual in the structured release program or alternative sentencings, or the program that would have permitted the petitioner to be placed in the structured release. A week later, so these prosecutors were contacted by the victim after the petition was placed on structured release, and then they filed this motion to clarify that all of the documents or the orders that issued from the court on May 22nd should reflect what the trial court intended to impose.
Let me ask you this, Mr. Roscoe. You said that the trial court had concurrent jurisdiction. You use that word under 9600. What if an appeal had not been filed? What would have been the basis for the court's jurisdiction after the judgment is entered, after the defendant has started serving his sentence, after the expiration of any time for motion for a new trial or reconsideration? What would have been the judge's basis for jurisdiction to come back and change a sentence?
And in that situation, Your Honor, it could have been potentially something, as opposing counsel was addressed. It could be, that would be an issue between the state attorney's office and also the sheriff's office, depending on whether or not, what rules were in place, what laws were in place, and whether or not.
Correct. But that's not what happened here. At the time this motion was filed with the court, all of that had passed. The judgment was and sentence was entered. The defendant was serving his sentence. There was could be no timely motion for reconsideration or new trial or any such thing. In fact, the state's appeal time, to the extent it might have had a right of appeal, had expired. What was the basis of the court's jurisdiction to entertain that motion?
In this, the motion to clarify, if I understand Your Honor's question.
The motion that the state filed with Judge Hellinger to, I think it said clarify. What was the basis? How could a court do that?
Well, that would have been pursuant to the appellate rules, and that was only
But the appeal hadn't been filed yet. The appeal was filed just before the hearing on the motion, correct? But what was the basis for the court's jurisdiction when the state's motion was filed?
Well, In the motion did not indicate what rule they were filing it under, but it's still the state's position that even though it had not, that the petitioner had not filed his appeal until the day of the second hearing on the motion to clarify, that the state would have been able to ask the court to clarify, to have the judgment, sentence, and commitment forms reflect exactly what the trial court intended under Rule 9600A.
But it wasn't anything it wasn't what the trial court said, correct? And it wasn't correcting a typo. Like, so the trial court said a year and 12 months and the Senate said 11 months. This was like what theoretically resided in the judge's head.
Yes, Your Honor, but also it was.
So could the state have filed a motion like, and let's take this out of this case and say it's a hypothetical and it's a felony. And the judge says, I want to give the defendant the maximum sentence and I sentence you to 10 years. And the state then figures out later on that really, maybe the judge could have sentenced him to 15. Could the state have gone back and gotten the judgment, the sentence changed because the judge intended in his or her mind to give more than 10 years?
No, Your Honor, and that would be.
And isn't that what's happened here, essentially?
But no, Your Honor, and I think that there may be, I think that there's something missing in between the first sentencing hearing on May 22nd and the order that issued after the hearing on June 15th. So at the hearing on the state's motion to clarify, the clerk had informed the court that all of the documents that issued on May 22nd, the original documents, so the judgment, sentence, and commitment form, the commitment form being the one primarily at issue, was reflected that the trial court intended to give, and the trial court, quoting the trial court, the harshest punishment is to the maximum I can do it. So the trial court, like I said, at the sentencing hearing on May 22nd, it was very clear that the only issue was whether or not the sentences would run consecutively or whether they would run concurrently. But a week after, so those documents issued on May 22nd, and that included language and that said that the sheriff shouldn't use this individual as part of the program, structured release program or alternative sentencing programs later. But then a week after that hearing, petitioner's counsel below contacted the clerk's office to request that the information be changed. Now, in the second hearing, the way that they discussed,
this wasn't, it didn't ask for a change in the judgment and sentence. That's correct. Asked that the commitment document that is executed by the clerk as a ministerial duty was suggested that it was inaccurate, correct? And the clerk went back and confirmed that it was inaccurate, that box was checked, and changed it. And as I understood somewhere in this record, that was not an uncommon occurrence.
It did not appear from the clerk's discussion that would have been, but it's still the state's position that, and that goes to the irreparable harm argument that the state does not believe the petitioner has alleged, is because instead of contacting, essentially, there's some inconsistency in the position that the clerk, by deleting the check in the box regarding the alternative sentencing, was correcting a clerical error, but that the trial judge, by adding the check back, was altering the petitioner.
Well, there is a difference, is there not? I mean, the clerk is supposed to be performing a ministerial duty and recording exactly what happened at the sentencing, and determined that, in fact, the judge had not made any sort of ruling that would have justified checking that box. The judge's determination, as far as I can tell, is not ministerial. The judge says, oh, I intended for the box to be checked, even though I never said for the box to be checked.
That's correct, Your Honor. The trial judge did not say those words specifically regarding the sheriff and the alternative sentencing program. But
In fact, though, even if you take her words, the harshest possible penalty, still in the custody of the sheriff on a consecutive sentence. I mean, I'm not sure that the alternative sentencing program or whatever it is called, this is essentially the sheriff housing the inmate somewhere other than in the county jail. I'm not sure that is inconsistent with the judge's determination to give him the harshest possible sentence, is it?
Yes, Your Honor.
He's
that
not
would
free to
be-
walk around. He's not, you know.
I think that it would be, especially considering that at the hearing, like I said, that there's, in the original sentencing hearing on May 22nd, that there was no discussion at all about whether or not he would be doing this time in jail or on,
At the sentencing hearing.
At the
So
sentencing hearing.
the judge didn't say it. Judge, there was no discussion at all. So the clerk clearly should not have checked that box and determined that they should not have checked that box. And as an administrative, clerical, ministerial matter, they unchecked the box because the document was inaccurate.
But but that changed essentially that's what petitioner is arguing here is that changing, adding or taking away the language referring only to the sheriff. So where the trial judge includes in the commitment form that the sheriff should or should not use somebody into this discretionary program is altering the sentence. It would be altering the sentence. It's our position.
Well, let me come back and ask you about that in terms of the same question I asked Mr. Altenburn. Assume the box wasn't supposed to be checked. I mean, obviously, if that box remains checked, that was not at the order of the judge in terms of the initial sentence. That would have been the clerk exercising some sentencing authority that the clerk does not have. And that's why the clerk unchecked the box when it was pointed out that, as you say, this was never discussed. Correct? But how do you, so let's assume, this defendant goes into this, assume it is discussed. How do you reconcile paragraph 13 of the administrative order, which was what was relied upon by the state at the hearing, at the hearing on the state's motion, with paragraph 12? One seems to say that the defendant, an inmate can't be put in this program unless the judge allows it, affirmatively allows it. And the other says that the inmate can be put in this program unless the judge disallows it.
Yes, Your Honor. And that would be, it's the state's position that regardless of whether or not it should be, the trial judge's decision should have been based on the local order 2018-20, paragraph 13, or whether or not it was the sheriff's operating procedures. Administrative
order paragraph 12.
Correct.
I mean, that's part of the same administrative order that the state was relying on.
Correct, Your Honor. And the reason, but the actual validity of the document or the correctness of the trial court's decision when it comes to whether or not the sheriff had the obligation or even the right to include petitioner in the structured release program is actually a question that follows the questions that this court would have to answer, because actually this case could be determined, or it should be determined before ever getting to that question. And that is that it's the state's position, like I said, that whenever the sentencing counsel contacted the clerk, or instead of contacting the clerk to alter the commitment forms, that a motion should have been filed at that point to correct whatever inconsistencies it believed was in place or that conflicted with the
Why?
oral pronouncement.
It wasn't up to the judge, right? That commitment form, judge never touches it. Judge didn't sign it. There's no suggestion the judge ever saw it. That was just the clerk theoretically carrying out the sentencing decision of the judge and the form did not accurately reflect what the judge had announced. Why does the judge need to be involved? I mean, as didn't the clerk's office say this is actually a fairly common thing for defense counsel and probably state's counsel to contact the clerk and say, you know, that form is incorrect. That doesn't reflect what would happen.
Well, we believe that, I mean, it does have some kind, it is an order that issued, although Your Honor's correct, it was not signed by the judge and it was just administered by the circuit clerk.
It's a ministerial duty. The clerk doesn't have discretion, correct? Ministerial
Right.
duty of the clerk.
Issuing what it believed the record reflected.
So really, maybe what you're saying is rather than just call the clerk, the defense counsel should have filed a petition for writ of mandamus directed to the clerk, to tell the clerk to submit an accurate form.
Correct, Your Honor. And in any case, whether it was either through petition or either through a 3800B motion, because it's saying that the
But
sentence.
that mandamus petition wouldn't have gone to Judge Hellinger, correct? That would have been a civil action.
Well, correct, but the state believes that the more appropriate way, and which would play into the irreparable harm that the petitioner is required to allege, and that is that if a motion had been filed to correct the trial court's error, that the issue could then have been appealed to this court, just as the petitioner would have had an appropriate remedy or an adequate remedy on appeal if, instead of contacting the clerk to change it and then having the state come back to file the motion to clarify, it had just filed a motion with the court to address what it actually what it wanted the court to say, and that was that the petitioner should be or could be allowed to be placed in this discretionary program by the sheriff. But that would have been.
Wouldn't that have been altering the sentence that the judge pronounced? I mean, the judge, as you point out, this was never discussed at the sentencing hearing.
Correct. Not the specifics of whether or not he would be spending that time in jail. Said because or whether or not it would
whether he as an jail inmate, now he's beyond being a defendant, he's now a jail inmate, whether the sheriff could put this inmate in this program. This was never discussed at the sentencing hearing.
At the original, it was not, because by the time of the sentencing hearing, he had already been in jail for 13 months. And so every time
whatever, the judge, it wasn't discussed, the judge didn't include it in the sentence, any mention of it at all, one way or the other.
No, Your Honor, but it's still the state's position, like I said, that the sentencing hearing transcript clearly reflects that, and also the fact that the clerk actually checked the box on the day of the sentencing hearing, the day that commitment form issued, that it was very clear at the sentencing hearing that the petitioner was not entitled to participate in the program.
Well, there was a suggestion. There's a suggestion. Again, it's not fleshed out. The Judge Hellinger does not ever allow one of her defendants to go into this program, and therefore the clerk might have checked this box before the sentencing hearing ever started. But that, again, it's not fleshed out. So, we'll just assume that it got checked inaccurately based on what happened that day.
Well, because it's also the state's position that this was not a condition of the petitioner's sentence. The information that was included in the commitment form was a completely discretionary directive aimed entirely at the sheriff, pursuant to the local rules about whether
how in the world does the judge interfere with that now? Especially after the fact. I mean, she couldn't do that if we were talking about the Department of Corrections. Case law is real clear about that.
Well, in the only way, I mean, the longstanding rule in the area, well, there was actually no disagreement. The only disagreement about at the second hearing on the motion to clarify was actually whether or not it wasn't very clear whether or not the trial judge was required to say either that you cannot participate or that this person should participate in either direction, whichever way they were required to notify the sheriff. But because it was not a condition of the sentence, it's the state's position that the trial court was not required to orally pronounce this at the sentencing hearing, because there was actually nothing. Petitioner was never entitled to be placed into the program or the structured release program. It was not an entitlement. It didn't give him any rights to do so. It was just a directive by the trial court informing straight to the sheriff saying, hey, if you look through all of these paragraphs and all of this program, then if you get down to the very end, then either this person can or cannot participate. It certainly doesn't give any defendant sentence under the rule any rights to participate in the program. And
Okay, I've helped you use up your time, Mr. Roscoe.
thank you, Your Honor. The state would request again that this court dismiss the petition. And thank you.
Mr. Altenburg.
A couple things in brief reply. The commitment, I think, is actually probably a red herring in this case. You're correct that commitment is a ministerial obligation of the clerk. The hearing kind of went off on the side on that because the judge got very upset when she found out that my co-counsel had contacted the clerk to make sure that this was correct. And what happened was that when the Zoom part of the hearing was over, the hearing continued with the clerk explaining this whole process. So I wasn't even there when that went on. I found it out afterwards. But as a practical matter, the commitment document itself is just used to transmit to the sheriff the proper sentencing documents. And so the sheriff is supposed to, like DOC does, establish the proper circumstances of this prisoner in terms of the length of the sentence from the judgment, and from the sentence, not from the commitment form. And at all times, the sentence in this case, orally pronounced and in writing, had nothing in it about this special prohibition about the sheriff using an alternate electronic monitoring system. So I do think the commitment is just off to the edge on this. And if the state is correct that this is not even part of the sentence, then I don't understand why the judge has jurisdiction to do anything here. If this is the sheriff's separate executive department
If this
program.
was part of the sentence, how does the judge have any jurisdiction? It is.
Yeah.
I mean, I just don't get what the jurisdiction was.
I don't either, but if it's not part of the sentence, I really don't get it.
Really, yeah.
And so, again, and obviously this is irreparable. We can't get this done in the next 75 days in the direct appeal. And, you know, this is one of those rare cases where I've taken the case because my client is not interested in their due process rights to property. This man is interested in his due process rights to life. He does not want to go back on cell block C because he is an extreme risk of
His
COVID.
medical issues.
Yeah, and this is not going away. This is getting worse in the jail. So I would ask for the relief requested earlier, unless there's any additional questions. I thank you for my first opportunity to ever argue a cert petition in any court in the state of Florida.
Well, really, I'll tell you the story. So one time I once, many years ago, argued a petition for writ of habeas corpus in oral argument in front of a panel that included Judge Ott. Yeah. You did well under fire, Mr. Roscoe. You're muted here, but.
Thank you, Your Honor. Thank you.
Okay, you guys, in order to leave, press the leave button that is in the lower right-hand corner of your Zoom screen, and you'll be gone, and we can call the next case.
Thank you again.